Well, hello, everybody. Welcome. Good afternoon. Thank you so much for joining us today at our Casey webinar series that we like to host. Before we get started, just a couple quick housekeeping notes. Today's session is being recorded. We will be saving time at the end for questions. Please feel free to drop them into the Q&A at any point, and we'll fit them in where we can. Otherwise, we will have time at the end for those. I'm Natasha. I'm from Kelly Cawthorn. For those of you who aren't familiar with Kelly Cawthorn, we are a lobbying firm here in Lansing, Michigan. We like to host webinars on various different topics throughout the year, just to invite clients and the public to hear something interesting that we have to say. Today, we are having Jody Schaefer with HRM Services. Jody is a certified senior professional in human resources and the owner of Human Resource Management Services. Jody has a bachelor's degree in psychology and education from Kalamazoo College and over 20 years of experience in human resource management. She was recognized as one of the 10 over the next 10 in the next generation of business leaders by the Lansing Regional Chamber of Commerce and accepted the MSAE Association Choice Award on behalf of HRM for the consulting services category. Jody sits on several statewide committees focused on human resource policy and leadership development. She is a regular contributor to various industry publications and author of a ready-to-use HR system for small employees. Jody conducts speaking engagements and training seminars on all aspects of human resources, including employee relations, leadership skills, performance development, onboarding, recruitment, and retention. And with that, I will turn it over to Jody.
All right, thank you very much. I feel the need to apologize to any of those who tried to join this exact same webinar last month. I had some internet difficulties and didn't realize it at the time. And then the webinar sort of cut out 10 minutes in. So thank you for coming back. We're trying it again. I'm going to talk about a couple different things today. I'm going to give an overview of the Earned Sick Time Act, kind of 1 year later. What are we hearing from employees and employers? What are some of the sticking points? What are some of the best practices that we've learned? And then I want to give you an update on sort of what's happening at the state level and the federal level, just in terms of some employment law compliance things to keep on your radar. So before I get into that, a little bit about HRM Services. So we are an HR consulting and training company here in the Lansing area. We service clients all over the country, but a lot of our clients are here in Michigan. We do various things. Training is my favorite thing to do. Of course, with a background in education, you can probably see why. So we do a lot of training, leadership coaching, but also HR consulting and outsourced HR. So as we go through today, if I hit on something and you're like, gosh, I'd really like to talk through our specific policy on that, and maybe there's some changes that could be made, we would be happy to do that alongside you. We do a lot in that space with employers, again, of all sizes, but predominantly those here in Michigan. And then on the outsource side of things, if you're looking to have some HR support, but don't necessarily have the expertise in-house, or maybe you don't feel like you have a big enough need to support a full-time hire, potentially outsourcing that function is something that's worth considering, and that's another part of our service line. At the very end of today, I'm going to share with you some resources as well. We do a lot of content generation. It's free. You don't have to be a client of ours to access a lot of our videos and our templates, articles that we write, because we understand that managing people and managing compliance, it's a full-time job. And so we want to try to come alongside and support wherever we can. Okay, so let's jump into it. I've got about 45-ish minutes of content just to allow some time for Q&A at the end. And I want to start by talking about the Earned Sick Time Act. I know many of you are probably sick to death of hearing about this. It was a whirlwind getting this across the finish line. Last year, coming into February of 2025, which was kind of the compliance date for large employers, and then last October for small employers. This was something that was like a will it, won't it happen kind of question for, several months leading up to the implementation date. And we knew, employers knew, those of us who were kind of working alongside employer advocacy groups knew that the way that legislation was written and was going to be problematic for employers. And I should just clarify that the Earned Sick Time Act came out of a citizens initiative, so it was a ballot proposal that sort of never made it to the ballot. It was adopted outright by our legislature so that it could be amended, and that was way back in 2018. And then legal battles ensued because the amendments at that time were pretty significant. So as the courts all weighed in on this, eventually it made it all the way up to the Michigan Supreme Court, which eventually said, look, you got to go back to the way it was originally written. And that was going to be really difficult for many employers to manage. And so there was a big lobbying effort that happened at the state level um, to try to get some amendments worked back into that before the effective date. That did in fact happen, but it didn't happen until the effective date. So it still was like a lot of sort of last minute racing around trying to figure out what the rules were, how we were going to implement them. And so now, for large employers, those of you that have 11 or more employees, you've been living with ESTA for a year now, just over a year. For my small employers, 10 or less employees, you've been living with ESTA for about 6 months. And so we have recognized that this created some pretty significant changes, not just to paid time off policies. I mean, that was sort of the obvious one. We were going to have to take a look at who was currently getting paid time off. For many employers, especially small employers, they were offering some paid time off, but not necessarily to every category of employee. Well, ESTA applies to all, even your temporary workers. So we knew we were going to have to make some changes to time off. Um, but we also had to make some changes to eligibility rules, to reasons that you could take this time off. It became much more comprehensive. There were significant changes to notice and call-in procedures, specifically an employer's ability to enforce notice and call-in procedures if the reason the person was out was unforeseeable. So that is challenging. And then, of course, the discipline component, essentially, this is a benefit afforded to all employees. Therefore, you cannot discipline an employee or withhold a bonus or an incentive from an employee because they used ESTA. So we have to look at bonus eligibility requirements. Sometimes, even around like holiday pay, we read a lot of handbooks that talk about, we'll pay you for this holiday, assuming you work the day before or the day after. Well, again, if the reason that you didn't work the day before or the day after was because of ESTA, then withholding holiday pay could be considered punishment or, discipline. So we had to look at our holiday rules and potentially rewrite some of those. And then of course you've got coordination with other leaves that might also be for health related reasons. So just it disrupted much, much more than just paid time off. Um, the other component of this that also was a lift to employers had to do with the documentation requirements. So anytime employers are changing workplace policies, they really should be documenting those changes. For those of you that have a handbook, this would be a natural place to make those updates. Some organizations don't have one comprehensive document called a handbook. They have standalone policies and procedures, which is fine, but that meant that those had to be updated and distributed. Employment law posters had to be changed. Now, ESTA wasn't the only change that happened last year, and I'll talk about the minimum wage increase and a few other changes when we get to the state section of the updates today. But there were a lot of things that changed last year. So every time a law changes, your employment law posters have to change to keep pace. So that also was a change for employers. Um, there's a requirement in ESTA that employees receive notification of your ESTA policy and how they are specifically going to be impacted by that. Not just your existing staff that were with you when ESTA became effective, but any new hire you make from now until the end of time. So your new hire packets, your standard new hire materials also had to change because there are now new forms that are part of that specific to ESTA. And also on the back end, when an employee leaves you, that separation checklist now should probably have something around ESTA. Whether or not you're choosing to pay it out, it's not required that you do, but just letting people know how that works. So, updates to policies and lots of policies, not just time off, and updates to many, many documents. So, it's been a year or 6 months, again, depending on your size. What are employers seeing? What are some of the things that we're hearing? So I'm going to share with you this employer feedback. This is feedback that we have received directly. Again, we work with over 1,000 clients, and so we get a lot of feedback around this issue. And we were kind of at the forefront of helping employers become compliant with this. So we were sort of really ingrained in this whole ESTA business. But I also sit on a committee at the Michigan Chamber, the Health and Human Resources Committee, and the legislature had asked the committee to come and provide kind of some feedback on how it was going. So this is also a compilation of some of the feedback that they received from their members too. So I'm just put it in some major categories here. Employers continue to struggle with the lack of exemptions. Um, ESTA is the law of the land for Michigan employers or for any employer outside the state of Michigan that has somebody working remotely in Michigan. You have to comply with ESTA for at least that individual. Um, but if you had a really generous time off plan, I mean, some of our employers have only salary level employees. They essentially have unlimited time off, and like that wasn't good enough. They still had to go through and make sure that they had specific carve out language for ESTA. The small business exemption was another struggle point. ESTA defines small business as 10 or less employees. Some of you listening to this, if you have 12 employees, you certainly don't consider yourself large, but under ESTA, you're considered a large employer. So that's a struggle. I think a lot of employers were hoping for, maybe the threshold would be set at 50 or less for a small employer, or maybe they would carve out small employers like they tried to do the first time around. But nope, everybody has to comply. Uh, Not-for-profits have to comply. And just because you have even just one employee, you have to comply. And then the other exemption component, we have a lot of clients that have seasonal employees or temporary employees. And this was a real struggle for them because this was a category of employee that might not have historically received paid time off. So now it's a new expense item, and the tracking component and the usage component is really hard to staff for, which kind of takes me to this next section of complaints, which essentially is employee abuse. Now, I don't see this across the board. I don't hear from every single employer that, yes, just because of ESTA now nobody comes to work, although that was a fear for some. But I do hear it in some industries. There seems to be certain industries where ESTA abuse is much more rampant, and different categories of employees. So one example of this, I have a client and they're a healthcare facility. And I was asking about this, how's it going? And they said our clinical positions, which essentially are mostly salary or exempt positions, we don't see much of a change there. But our hourly positions, specifically like front desk, where it's low skill, sort of entry level positions, it is really, really difficult to get employees to commit to a work schedule when they have an ESTA bank. Essentially, their experience was that those employees are burning through that ESTA bank until they don't have any time left, which makes it difficult to staff. Another concern around employee abuse is that the word retaliation remains undefined. The ESTA law says that you cannot discipline or retaliate against employees for using their time under ESTA, but it doesn't define what retaliation is. And the guidance from Leo also isn't really clear around this. There continue to be challenges around this, no notice leave equaling increased absenteeism or call-in, sort of this unscheduled, unplanned. So to the example that I just gave. And when that happens regularly, It's leading some employers to see a loss in productivity and increased costs because essentially the folks that are coming to work are being asked to work more. So potentially you've got overtime costs there, or they're having to overstaff certain positions because they can't trust that this person will work the hours that they said they would work. Additional feedback, there are some administrative complexities. I hit on a few of these. Um, the lack of a cap on that carryover bank is just a bit of a head scratcher. We still can't really figure out what the law was trying to get at there, because if you'll recall, there is a cap on usage. So no matter how big the bank gets, it doesn't matter because you can only use, either 72 or 40 hours in a given year based on your size. So why is this bank allowed to just get bigger, 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 bigger if they can never tap into the extra? Additionally, there's no requirement that unused hours get paid out at the time of separation. So again, there's no real benefit to having this very large bank other than employers having to track all of those additional hours. So again, it's a bit uncertain why that was built into the law, but it continues to be a bit of a frustration. Um, Another one, and again, it doesn't make a lot of sense, but if you choose to front load your ESTA bank, or if ESTA is combined with PTO and you front load those banks at the start of the benefit year, and you say, look, here's your hours. We don't care how you use them. We're not going to say yes or no. They're yours to use. Employers are still supposed to be tracking any hours that were taken for the purposes of ESTA. So if I lumped it in with PTO and I said, use it how you want, I'm not asking questions, and the person's not used to providing any sort of documentation to use their PTO, now all of a sudden they still have to tell you if I'm taking PTO, but this is ESTA PTO, right? Just so the employer can like mark it on a sheet somewhere. Not that you turn that in, but I guess if you were ever audited, you need to have that. So it's just, again, it's a bit of a frustration. Some employers are using payroll systems and electronic time off systems where those submissions for time off are coming in electronically. And they're having to create workarounds in those systems so that people can put in the notes section that it's ESTA. It's just kind of a pain. The documentation, this has to do with requiring documentation. The employer, if they don't necessarily believe that the employee is telling the truth, they can't ask the employee to justify the absence with documentation unless they've been out for more than 3 consecutive days. And it's that consecutive part that's really hanging employers up. So if I'm out for 4 days, but it's for 4 different reasons, according to myself, right? Because I'm self-reporting that, then as the employer, I can't ask for documentation because it's 3 consecutive, right? More than 3 consecutive days for the same reason. So it's a bit of a game and it's causing some frustration there. Um, I get asked a lot whether or not the legislature is going to dive back into this. Now that they've received all this employer feedback, they're going to do something, right? Well, yeah, it's a divided government at the state of Michigan, like it is, at the federal level, and there's just not a lot that's getting done. And to be fair to this group, the current legislature that brought about the existing amendments that we have, they were they were brand new legislature. Like they were seated last January. And so they were, had to be sworn in, brought up to speed. Like typically a brand new legislature doesn't dive into a lot of, serious work until a little bit later in the term because they have to get their feet under them. This legislature had until February 26th to decide if they were going to do anything or not. And so I give a lot of credit to the folks sitting on both sides of the aisle for the amendments that they were able to get passed in a very, very short time frame. But it was exhausting for them. I think a lot of political capital was expended, and I don't think anyone's really excited to sort of reopen this right now. So maybe, I mean, we continue to look for ways, but I don't think significant changes are on the horizon. So, what are some best practices around ESTA? I've listed 5 here, some things that we give a lot of guidance about. The first is that when an employee calls out unexpectedly and they say, I'm not going to be in today or I'm going to be late today, right? And it was unscheduled, unplanned, especially if you have a PTO system, employers need to get in the habit of asking at that time, is this ESTA? The person doesn't have to tell you the extent of it. They just have to say yes or no. Because what was happening is I have a lot of clients who have PTO. They aren't used to asking why the person's going to be out. They just see that they're going to be out. And then all of a sudden it feels like this employee has done this unscheduled absence thing several times in a row, and it's starting to affect the workplace. Either it's starting to affect production, or their coworkers are starting to get really frustrated about having to pick up all the slack. And so now they want to try to get involved. And I say, well, you don't even know if any of those absences were ESTA. So that limit as to how many hours of ESTA you can take in a given year, essentially, you've not started the clock on that yet because you haven't asked and they haven't told you. So if you're giving 80 hours of PTO or a generous amount of PTO, more PTO than what ESTA would require, and you're not asking for those unscheduled absences, if they're ESTA or not, you could sort of be delaying the point in time where you could really have some consequences. Because for the first 40 hours, if you're a small employer, or 72 hours if you're a large employer, it's essentially hands off. You can't tell them no, and you really can't do anything about it. But once they hit that threshold, now you can start to enforce whatever discipline you want. But if you haven't started the clock, it's pretty hard to do that. So, you know, guidance number one, ask them if it's ESTA right in the beginning, because if the answer is yes, you can start the clock. A second thing that we're seeing a lot of employers do is they've started using these bifurcated systems where they'll have different rules for different categories of employee. So for their full-time employees, the ones that are used to getting paid time off, those folks might be used to getting it in a lump sum at the start of the year. They just kept that as kind of the rule, and they made sure there was enough hours there to cover ESTA. But for folks that aren't used to getting paid time off, maybe your part-time employees, temporary employees, etc., maybe they have a different set of rules. Maybe they earn as they go instead of front loading. And maybe they only get up to the ESTA max. They don't get all this additional time. I've seen employers do that also for like a new hire versus somebody that's been with you for more than a year. So they might say new hires are on this earn as you go, because in that scenario, I don't even have to give you access to your bank until you've been there 120 days. So, with a new hire, you're crossing your fingers that they're going to be the right fit, but you don't always know how that's going to work out. So, at least in that scenario, you haven't given them access to a benefit before you had to. And then you can sort of see how it works out. So, they might have new hires on this different sort of system in terms of the award. Um, than they have once you hit the 1 year and we know that you're going to be a good fit, then maybe we flip you to a front load. So you can do that. You can have more than one set of rules as long as you're treating the same classification of employee the same way. I have encouraged employers to have impact conversations. You can't discipline folks for taking ESTA, and you can't retaliate against them or withhold bonuses or rewards, for taking ESTA. So it becomes difficult to incentivize the kind of behavior that you want. But there's nothing that says that you can't sit an employee down who's using a lot of their ESTA and it's, again, unscheduled, unplanned, and you're questioning whether or not it's real. Maybe they don't care what you think. Maybe they think they're entitled to it because the law says they get it. But maybe they care what their coworkers think. Not always, but sometimes. So sitting down and explaining kind of the trickle down effect of somebody calling in unexpectedly and what that does to the workplace, and then who has to pick up the slack on that. Those kinds of conversations are absolutely allowed, and I think you have nothing to lose. So you might try that. Um, Another thing that I'm seeing employers consider, even though the law doesn't require employers to pay out for unused ESTA hours at the time of separation, there are some employers that do this kind of risk reward analysis and they say, look, let's say I have employees that aren't abusing ESTA. That's not a problem I'm having in my workplace. And they know when they leave, they're not going to get paid out for any of those unused hours the way that the law is written. But maybe I want them to work as long, like actually physically be here for as much of that notice period as possible, rather than feeling like they have to hurry up and take those hours or they're going to lose out on them. So maybe I choose to pay out for unused ESTA hours at the time of separation. If the separation was voluntary and you were an employee in good standing and you returned all of your equipment, right? I can put kind of criteria around that. But perhaps I want to, in that way, incentivize people to use ESTA appropriately. And I say, I'll pay out for unused hours so you don't feel like you're losing anything. It's something you could consider. And then the fifth one, and I don't love this one because, it's like a band-aid. But I do have some employers that have started just overstaffing for certain positions that have kind of this now pattern of ESTA abuse. And so instead of hiring one, I might hire two or three, and I'll say who makes it through the first few months and then go with that. So, it's not as if the talent pool is huge right now. So this one is not a great suggestion, but I do have some employers that are doing that. Okay, I'm going to just pause for a minute because I'm going to shift into some state updates that are happening, not just specific to ESTA, but are kind of across the board on all things that touch HR. And then I'll do the same thing for federal. But before I make that shift, does anyone have any questions specific to ESTA? Tasha, have you seen anything come in?
No, not specific to Esther right now.
Okay. So just a reminder, there's that Q&A. You're welcome to submit any questions, and I'll save some time at the end for those as well. Okay, so what's happening at the state level? What do you need to keep your eyes on? Um, I'm going to talk about a few things that have already happened, and then I'll talk about some things to keep an eye on that we're watching at the state legislature. So, one of the things that has already happened, and it affects your budget, is the increase to unemployment insurance benefits. Now, this actually started back in 2025. But every year, it happened in 2025. It's going to happen this year in January on the 1st. It will happen again next year, again the following year, and then it will be tied to inflation thereafter. So essentially, this is the maximum amount that a claimant could receive in weekly unemployment benefits. That maximum amount is set to increase annually. To try to keep up with pace of inflation. So there are some scheduled increases, and I have those outlined below. Right now, it's $530 a week. That's the weekly benefit max. Last year, it was 446. Next year, it's going up to 614. So you can just sort of see that stair step increase. Another change with unemployment insurance benefits is that the number of weeks somebody could receive benefits has gone from 20 weeks to 26 weeks. It used to be 26 weeks, and actually, most of the states in the country have a 26-week window. So, we scaled back on our benefits when we were going through the, 2008, 2009 financial crisis here in Michigan, and we were trying to conserve that unemployment trust fund to the extent that we could because we had so many people drawing from it because of the recession. One of the ways they tried to conserve dollars was to minimize the number of weeks somebody could receive benefits. So we're going back to sort of how it used to be here. So now it's 26 weeks again. That happened back in 2025, and it remains that way from here. So no change to that going forward. That'll stay at 26. It's just the weekly benefit amount that's going up. Another change that's happening at unemployment, and actually today is a deadline for this, unemployment is shifting their platform. Many of you are probably familiar with the legacy platform called MyWAM. That was the platform that we used to communicate about claimant benefit information. That was the platform that we looked at for our own account information, and that was the platform we used to submit our quarterly tax filings. They're shifting to a new platform called MyUI. They're going live for taxes first. So today is actually the deadline for that. So if you've not done this transition yet, you need to do it and you need to do it today. You essentially log into your MyWAM account because there's a code that you need to get from that account. You need that code to set up your account on My UI, which is the new platform. And then essentially it will sort of link all of your employer information over from the old account to the new. But you need the code in order to do it. And then once you set up the new platform, if you're using a third-party payroll company to file your payroll, your quarterly tax filings for you and your reports, you'll need to make sure that you select them as your authorized third-party administrator on the new platform. So not everything carries over. Some you have to go in and make adjustments. So that's for the taxes. That is live now. And then the claimant information, the benefit function will shift over to that new platform. They're saying this summer. So we'll kind of see MyWham go away and be replaced by MyUI. One final change on the unemployment side here in Michigan is that there's a change to the work search requirements. So if somebody is receiving unemployment benefits, one of the things that they have to attest to every week is that they are willing and able to work and that they're actively seeking work. So they have to do these work search activities to prove that. The current requirement is one work search activity per week. That's going to be increasing to three work search activities per week in July, which I think many employers are happy about. I'm asking the question, well, like, how are they going to monitor that? And I would love it if they had a portal where like employers could report John Smith was scheduled for an interview today and no showed, right? And that way, if John Smith is in the system, then, because otherwise I don't know how they're going to know. But essentially, right, this is like self-reported from the claimant side, but that's going to increase. Okay, so that's kind of what's happening at UI. Now, there's something that it's a UI component here, but this I still don't think has come to resolution. I think everybody needs to know about it. So back when COVID happened, like cast your mind back 5 years ago, COVID, uh, everyone was in disarray, of course, and employers especially. And a lot of employees, unless you were considered an essential worker, were shifted remote or the jobs were just like closed down. You went on unemployment until the state authorized you to sort of open back up again. So the unemployment insurance system was flooded with just tons and tons and tons of claimants. And the system was not set up for that kind of volume. They could not keep pace. There was a real push at the state and federal level to just get dollars out the door so that people weren't struggling. And there was a lot of federal money flowing in as well to kind of offshoot or offset the state benefit. So benefit levels increased dramatically during that period of time. And one of the things that our state agency did to try to just push money out the door was they turned off the features they had in their system to identify fraud and overpayments. They just turned it off. And so they're just pushing money out the door, and it resulted in $2.7 billion, billion with a B, in overpayments. Now, these aren't payments that went to people fraudulently. These are folks that believed they had a legitimate claim and they were paid inappropriately or they were paid more than what they should have been paid. So this was an agency error. So there are all these claimants that followed the rules, submitted claims, received money, and now the agency looks back and says, "Oh, whoops, we made a mistake. You shouldn't have received those dollars." So 2.7 billion in mistakes. Much of that 2.7 billion was federal money. Remember, the feds were, they had an unemployment benefit as well to just really supplement and enhance the state version. So most of this money isn't state money, it's federal money. Well, guess what? The feds want their money back. And so at the state level, a law was put in place that said, look, agency, you can't go after overpayments that are more than 3 years old when the reason the overpayment happened is because of your own mistake. Claimant shouldn't have to bear the brunt of your mistake. So that means that the claimants aren't having to pay back the money. So the question is, where is the money going to come from? And the fear is that they will try to take some, I don't think they can take all, but a large chunk potentially from the unemployment trust fund itself. That unemployment trust fund in our state is 100% employer funded. These are your dollars. And the current fund balance is 2.9 billion. If they tried to take these dollars from the trust fund, it would bankrupt the fund. So there's a couple of things happening. One, you've got groups like the Michigan Chamber really sounding the alarm here, going, wait, 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 this is your mistake, state. You need to come up with a way to pay it, and you can't penalize employers any more than you can penalize claimants. You shouldn't be able to touch the trust fund to pay for your mistake. So the state's asking the feds to waive this debt. I don't think that's probably going to happen, but they're like, well, maybe. But assuming that the debt does in fact have to be paid, then there's a push that there's a different way, a different appropriation for that it doesn't come out of the trust fund. So currently, this bill is pending in the House. I think the lawmakers don't want to penalize employers, but they have to do something. And I just don't know if they've come up with a fix yet, but I want this to be on all of your radars. Okay. Any questions on that? Okay. Okay, what else is happening at the state level? At the same time that unemployment is increasing, right, on January 1st of every year, minimum wage is also increasing on January 1st of every year. So right now, minimum wage is $13.29, but that will continue to go up every year as the tipped minimum wage continues, right, to drop. So we're going to eliminate that tip credit eventually, and then it will be tied to inflation. So I bring both of these things up because both of these things have very real financial impact to employers. And even if you're an employer that doesn't have kind of low wage earning positions in your place of employment, maybe you don't have folks that make minimum wage, there's still this mindset with employees that like if minimum wage was $13 and I'm being paid $14, right? A dollar more than minimum wage. Then when minimum wage goes up to $14, I'm not going to be happy just staying at 14 anymore. I want to be 15, right? So like this, they call it wage compression, but essentially when you continue to raise the floor, there is this kind of ripple effect on all of the pay ranges above the floor. So this will affect all of you when it comes time for budgeting. And on the unemployment side, if the benefit amount is increasing and the number of weeks employees or claimants can receive that benefit is increasing, it's going to put more strain on the trust fund. So where do you think the money's going to come from, right? It's 100% employer funded. So we do anticipate seeing increases to the unemployment insurance tax rate for employees that have nothing to do with your experience rating. It's just simply to sort of keep that fund balance solvent. But these two things combined are going to hit your budget at the same time. Other things that we're just sort of watching now. These are not things that have happened, but they might. So we're just kind of keeping an eye on it. One has to do with job application questions. This is Senate Bill 145. In Michigan right now, we can ask about your prior salary at past positions. Some folks fill it out, some folks don't, but in Michigan, we can ask that question. That's not true in every state, but it is true in our state currently. We could ask about your credit score. Now, it should be job related, right? If you're working in finance and you're making decisions around how to manage an employer's assets, it's not uncommon that we would want to run a background check and potentially a credit check for that individual to make sure that they're handling their own personal finances appropriately. So there are reasons and rationale for why employers might ask these things, but Senate Bill 145 would prohibit questions about from job applicants about any of this. The language is really broad right now, which is concerning. There aren't any exemptions right now, which also is concerning. There are some positions where federal law requires that some of these checks be run. And so you'd have this intersection between state and federal law. So, which do you follow? And then employers still have this liability. There's something called the negligent hiring doctrine for employers. Employers can face liability if they knew or should have known that there was a reason that this person shouldn't have been hired, and they hired them anyway. Essentially, you allowed a risk into the workplace. And had you done a simple amount of due diligence, you would have found that out. And so, therefore, any harm that that person caused in the workplace could potentially be partially on the employer themselves, the one that made the hiring decision. So even if this Senate bill were to pass and some of those, due diligence type questions were now banned, we couldn't ask them, we're still potentially going to be held to this negligent hiring doctrine. So how do you, make those two things square? So lots of concerns on this one. I think generally speaking, HR best practices, if you have a business related reason for asking the question, then it's okay to ask. Just simply asking it because you're curious is not defensible, in court. So we already have some rules around this, but this would take it much further. Another bill that I'm watching, and this one has kind of been sitting there for years now. It's this total ban on non-competes. This is a House bill. It remains in committee. Again, we have a divided legislature, so I don't see this going anywhere right now, but that's always kind of being talked about on the edges. Another one that would allow local employment law. Uh, this one is interesting. So in Michigan, some years ago, Michigan preemptively passed a law at the state level that said no local municipality can have laws more restrictive than state laws. And so if you think about this from an employer perspective, if you are an employer and you have multiple locations across the state that might sit in different counties or different cities or whatever, this ensures that there's essentially one set of rules, no matter where your businesses are located within the state, that you're just going to have to follow state law. If this were to pass, then individual units of government could have individual sets of rules. And so then if you had multiple locations, now you're having to keep track of multiple rules. It feels like a patchwork approach. And so that's concerning to many business owners. That bill is sitting in committee currently. There's some MIOSHA rules that they're looking at, independent contractor restrictions. I'm going to talk about this when I talk about what's happening at the federal level. But this would essentially make it even more difficult to classify someone as an independent contractor. It would mirror what California has, but it would actually be more stringent than California because it wouldn't allow for any exemptions. So this really flies in the face of some of what's happening at the federal level, which again makes that difficult for employers to walk that line. So that's kind of just a quick update on where we sit at the state level, things that have already happened, things we're watching. I'm going to do a similar approach here on the federal side, but before I do, Tosh, any questions on anything I've just shared? Oh, you're muted.
Nope, no
Okay.
questions yet.
Okay, very good. This is also my check to make sure I'm still with you all. My internet hasn't collapsed. Okay, last bit here on federal updates. So, President Trump continues to test the limits of executive power. There have been a lot of court cases, right? You've got the executive branch saying, well, let's just see what happens if I push the boundary on this. And then inevitably, somebody doesn't agree with that decision. And then you seek this legal remedy, and then the courts get involved, and sort of here we go. So that's been happening a lot. Um, Early on in this most recent term, there was a push to really kind of crack down on affirmative action and really sort of put some limitations around DEI initiatives. And I just want to be really clear here for all of you listening that discrimination and harassment are still illegal. So regardless of what the administration's policies are around these two initiatives, affirmative action, DEI, discrimination and harassment are still illegal at the state level and at the federal level. So you have to be really careful about the kinds of things the practices that you have, and some of the training that you're doing. I still think it's a good idea to be doing anti-discrimination, anti-harassment training on a regular basis for your team so they know what's okay, what's not okay. Um, but these executive orders have absolutely put additional scrutiny around certain groups, certain benefits, et cetera. So depending on the space that you're playing in, you may have felt the impact of this more than others. There's also this federal push towards deregulation, this idea that the states should be able to sort of govern themselves within what's best of interests of the state, and that the federal government should sort of stay out of it and think big picture. We're seeing this in a couple areas. The Department of Labor has over 60 rollback initiatives, so they're really looking at a lot of different things, but I just picked a few. OSHA being one of them. So this is interesting. So in July of last year, OSHA proposed some changes that would relax the general duty clause, the general duty to provide a workplace free from known hazards. And essentially, the proposed change would say, well, look, some jobs are inherently dangerous, and you know that when you sign up for them. So those shouldn't be included in this. Um, the fear, I think, from some employers is this might lead to a softening around some other safety requirements, chemical safety requirements, medical, respiratory, et cetera. The note on this is that proposed does not equal final. So OSHA has proposed this relaxation of the general duty clause. That was back in July of 2025. And typically there's a 60-day comment period, and then the final rule would be published, and then we'd all have to comply. We're still waiting for any kind of final rule on this. So they sort of started it, and then it's just been sitting. So we just keep watching it. We don't know where it's going to go. Michigan does have, in Michigan, we have our own independent OSHA office, as do many other states. So in Michigan, some of our rules actually are different than at the federal level. So if you're operating within Michigan, continue to follow my OSHA, right? The Michigan OSHA rules. But I want to put that on your radar. Another change has happened around independent contractor. Remember, I said just a few slides back, there's been this bill, and it's kind of been circulating for a number of years now, that in Michigan, should we make it even more difficult for folks to be considered independent contractors? The Biden administration seemed to agree with that line of thought. So the Biden administration really tried to narrow the definition of independent contractor under Department of Labor regulation. And then, of course, President Trump comes in and he has a very different opinion about this. And so in May of last year, fairly early on in his first term, he says, you know what? I know that that's what the rule says right now because the Biden administration was able to sort of change the way that was written. But we're not going to enforce that. We're going to enforce it according to how it was written back when I was president the first time around. So that was tricky because, like, it's one thing for the DOL to say, yeah, we're not going to enforce certain things, but essentially the law is what the law is. And so if you were taken to court over your classification, you were still going to be held to what the law said at the time. Well, in February of this year, the DOL under the Trump administration did codify this change. So now they're saying it's not just that we're going to enforce it based on how it used to be written, we've actually changed how it's written to make it easier for folks to sort of fall in this independent contractor category. And so essentially, under the new law, there's just less things that we're looking at to test, and it's the nature and degree of control and the worker's opportunity for profit and loss. Those are the two key indicators. Now, the final rule remains in effect for private litigation. So again, it's kind of just tricky here. Anytime somebody doesn't agree or doesn't think you're doing it right, there's often legal recourse. And so it's ultimately the courts that decide how employers are supposed to interpret this guidance. But at the federal level, at least, we've seen this shift to a more broad definition. So Last bit on the federal side here, and then we'll have some time for Q&A. There have been some changes in the scheduling of medical marijuana at the federal level. So this is somewhat interesting because in Michigan, we have legalized both medical and recreational marijuana. But at the federal level, marijuana in all forms is illegal. And because it was scheduled as a Schedule One drug, it was in the same category as heroin. So like, very dangerous is sort of what that category is, which meant that researchers couldn't, get access to it to perform drug trials and that kind of thing. And so I think there's been discussion for quite some time about reclassifying at least medical marijuana. So in April of this year, the federal government did, it was actually just Thursday. So the federal government did reschedule marijuana from a Schedule One to a Schedule Three, which essentially says it's not as dangerous as heroin. And we recognize that there could be some medical benefit for this drug. Um, they're going to consider similar changes to marijuana more broadly at the end of June this year. So in Michigan, we're already sort of operating under this pretense, right? The feds are kind of catching up to where we as a state have already been. But there are some questions about what this might do with ADA accommodations and prescription drug coverage. If medical marijuana at the federal level could now be considered a prescription drug, if it was prescribed and received from a medical, pharmacy, um, does insurance have to cover it? I don't know, right? Or if I'm requesting a workplace accommodation, and one of the things that is part of my accommodation is that I utilize medical marijuana. The challenging part for employers is how do you then know if somebody's truly under the influence while they're on the job? Because employers can still have zero tolerance policies, but it's the testing that's tricky. It's not like alcohol where you can test how much alcohol is in your system at this exact moment. With marijuana, you're just testing whether or not THC is in the system and it's not at a certain level and it can stay in the system for a long time, days and days and days after you've ingested it. So you might not actually be high at the time of the test, but the test would say, yeah, it's in the system. So it becomes challenging for employers to sort of figure out uh, where they're going to take a hard stand for pre-employment drug screens, post-accident, post-injury drug screens, or reasonable suspicion. That's been our quandary for quite some time now. But if you have questions on that, we help guide employers through that all the time. So I will pause to see if we have any questions, Tosh, and then I want to share a couple resources for folks before we end today.
Yeah, we actually did get a question in on overtime rules. Could you kind of explain um, exempt employees versus non-exempt employees when overtime applies, and if someone is reclassified, when does that overtime start?
Yep. So exempt means exempt from overtime, exempt from minimum wage. In colloquial terms, we refer to those folks as salaried. Essentially, you get paid a flat amount of money based on the work you do, not how long it takes you to do it. That is a classification that employers really like because it's kind of a set it and forget it thing, and it's easy for me to budget. And if I need you to work a few more hours this week, you'll do so, and I don't have to pay you anything more from that. And it's supposed to be a give and take scenario. But there's the fear that employers will abuse that classification. And so the Department of Labor has put very specific rules around who can be classified as a salaried or an exempt employee. And it's based on two things. One, there's a minimum earning threshold. So the employee has to earn a minimum amount of money every year in order to even be considered for this in the first place. There was some back and forth on this a few years ago, but essentially the rate sits at like 35.5 is kind of the current rate. So they have to be earning above that. And if they're earning above that, then the next thing you look at is their job duties. There are different categories of job duties that would qualify you for exempt. Essentially, the more control you have over your work, the more ability you have for discretion and independent decision making on matters of significance. If you're directing two or more full-time employees, or kind of different categories, then the more likely you could be considered exempt or salary. As a general rule of thumb, blue collar employees are always going to be non-exempt. Non-exempt means you are not exempt from overtime or minimum wage, meaning you have to provide those things. So we refer to those individuals as hourly. And that's the classification that you could put every employee in if you wanted to. It's only if you want to carve people out of salary that you have to make sure that they fit, so to speak. For your non-exempt folks, the ones that have to be paid at least minimum wage and have to get overtime, the overtime is 1.5 times their regular rate of pay for every hour over 40 they work in your pre-established 7-day period. So it's not like if you have a 2-week pay period that you just say, well, they didn't work over 80 total, so we're good. No, you have to look 7 days and 7 days. There are some caveats to that, like fire and EMS and some healthcare can do some of that combined scheduling, but for most employers, it's time and a half, anything over 40 in a 7-day work week. Now, one note, it's regular rate of pay, which means if you have bonuses or commissions that are sort of part of their pay and they're non-discretionary, meaning there are certain rules. We say, if you want this bonus or if you want this commission, you have to do X, Y, and Z. And if you do X, Y, and Z, then you get this thing, right? So we have a plan. It's not like out of the goodness of my heart, I just decide to give you all a Christmas bonus. So if it's non-discretionary, there's a plan, then those bonus payments or those commissions also have to be factored in when you're trying to figure out 1.5 times what. It's not just hourly rate, because if you're getting these additional payments, those have to be factored in. So it's 1.5 times that new rate for the period that overtime. So it can get a little bit complex, okay? But just sort of know that that's part of it. Did I hit all of the pieces on that question?
I think so, yeah. Mhm.
Okay. All right. A couple resources I wanted to share for all of you because this is a big job, when you're managing people and you're managing compliance and the rules are always changing at the state level or at the federal level. Like, how do you know? How do you keep up? There are some free resources that are available to anyone, and I just want to make sure they're on your radar. The first is one of our resources. We put out monthly videos, they're like 10 minutes. Um, we have the entire catalog on our website you can access for free, but if you want to get on our mailing list for those, that's what this QR code is for. You can sign up for our mailing list. They'll come to your email. And sometimes they're on general topics. Like the most recent one was focused around teamwork, some things you can be doing in your practice or in your office to make teamwork better. And it was all kind of framed around the national championship win that the Michigan Wolverines had. But sometimes they're compliance related too. So if something's changing compliance wise, I'll do a video on that too. Law firms have a similar service. They're not videos, they're email messages, but you can go on a law firm's website, any of the large firms, Foster Swift, Miller Canfield, right, et cetera, et cetera. You don't have to be their client. You can go on and you can register for what they typically call like e-alerts, and you can pick the category of law that you're interested in. So in this case, it would be employment law, or it could be benefits. And anytime something's changing in that space, you'll get an email written in layman's terms that tell you what's changing, why it's changing, and what you need to do. So those two right there would be good ones to get. And then, of course, any sort of training sessions that are put on um, by either us or law firms or the chamber, et cetera. So kind of keep your eyes out for that. And then the final thing I'll just leave you with, we have a training coming up next month. It's in person in Okemos all day, and it's essentially the hard part of leadership. So if you're having employee issues, how to figure out what kind of an issue you're having. Based on that, what are the solutions that are available to you? And then how do you have the hard conversations? So actually practicing that, a framework for that. And then what does the documentation look like and how do you manage risk? So if that's something that you think would be helpful for you or anyone on your team, the QR code is here. I'll just tell you though, the deadline to sign up is May 1st. So like it's right around the corner. So if you're interested in that, that's the QR code and then I'm leading that one. So with that, I will leave you. Tosh, anything else?
I don't think so. That's all of our questions. And just a reminder, everybody, this is recorded, so we will get everybody access to the recording so you can revisit it if needed. And thanks everyone for joining us, and thanks Jody so much for being with us today.
Yeah, glad it worked out.
Thank you.
Bye,
Bye bye.
everyone.